Well, hello, Lyric Armstrong, your real estate agent and advocate. We are here and I have pulled out the facts. We are going with facts for Emily D. Baker and um, Gerard Cosmetics under the Law Nerds lip gloss. We're going with facts. We are going to Judge Middleton's court and we're going to learn what happens with the door-to-door salesman. Okay, we talked about this, I think, in Judge Simpson's court a couple days ago with regards to having a lien put against the house and what does that do to the homeowner and how does that affect the sale of a property. So we dealt with that because the township was cleaning up and they had to put an assessment of 13,000 and 14,000. That's in Judge Simpson's court, and how they dispense with that is quite interesting because Judge Simpson had to come down, bring his blood pressure back down so that he could deal with it. So check that video out. It's interesting. Today's video is regarding Judge Middleton's court. Yes, he is back from vacation. Yay! Thank you. Glad you're here. And we have one of his matters that he did in landlord tenancy where a door-to-door salesman got the homeowner to ascribe to a particular purchase. And now he finds himself in court. We'll figure out who's right and who's wrong and how this can escalate in your situation. So be careful. Door-to-door salesmen are, can be a great tool for selling product and get you great deals and things that you may need. Or you can find yourself in this situation where you get something you don't necessarily want. All right, let's see what happens. Judge Simpson, let's find you. Let's find your court. Here he is. We are in court. We are ready, Judge Simpson. I'm sorry, Judge Simpson. Judge Middleton. Like I said, we were Judge Simpson the other day. Now Middleton's back. So Judge Middleton, save us. What's going on? We will have the sound up, so unplug or turn down your sound so that you can hear.
I've got Kenneth Harker here. Good afternoon, Mr. Harker.
Good afternoon, Your Honor.
I've got Gary Feynman here. Are you here on the Fannie Mae case?
No, I'm here on the 1-800-Hansons LLC. Mr. Harker's the defendant.
Oh, yeah, that's the 145 case. So let me get that. Switch from landlord tenant to general civil for a minute. Mr. Feynman, what's your P number?
Good afternoon, Your Honor. P41-6.
Sorry, that's right. So this is out of general civil matter, but it does reflect in, because it's a contracts purchase matter, but it does kind of deal with home ownership and how these contracts take into consideration homeowners, and as a homeowner, what you should be considering when it comes down to responsibility. So it's not necessarily landlord-tenant laws that are being applied. However, it does affect home ownership in a way. So go ahead and just see this small case through. It's not long at all.
55.
We were here earlier on June 26th. Matthew Kuipers was here for the plaintiff at that time. Mr. Harker was here. The parties were put into a breakout room to discuss things. 1-800-Hansons was hired to install some gutters and do some other work at the defendant's house. The defendant was dissatisfied and contended that they didn't provide the product they said they were going to, and they gave a credit of, I think, $513. The company, 1-800-Hansons, is now suing for $4,655.00. We did discuss the matter, and we had settlement discussions on June 26th, but the matter was continued for the summary disposition motion here today. And
okay, so summary disposition can also be called a motion for summary judgment. So the plaintiff is the corporation who did the install on the house, and they are represented by the attorney. And then the defendant is the homeowner, and he does not have representation that has made an appearance in this case. And I say that way because he does assert that he does have an attorney, but yet they gave him some kind of summarized advice. but they're not working the case and they have not made an appearance in the case. So as far as the judge is concerned, he is not represented by an attorney. So motion for summary disposition means, Judge, let's not go any further in this case based upon the filings, the pleadings, all that you have before you. We don't need any testimony. We don't need to go ahead to trial or do anything additional. Let's have a summary judgment or summary disposition, meaning judge this case on what you have, on the documents you have. And a lot of cases are won that way. So for us in California, it's MSJ, motion summary judgment. A lot of times they have been won that way, especially in the past. Now, with certain civil liberties coming into concern, there are instances where the courts are taking the cases to trial and not granting the MSJs as easily as they would have in the past, because they want to get more of the merits and more of the information of fact to make sure that they are putting their order and their findings based upon, more substantive information. So MSJ, or a motion for summary disposition, is really at a point when you have a small amount of pleadings. You may have the complaint, the answer, and maybe a motion or two, and you really don't have much of the back and forth that goes into a case. So that's what the plaintiff is asking for. Judge, please make a ruling based upon the pleadings that you have already, is what they're asking for.
Here we are. Has there been any further discussion?
Well, Your Honor, I'm just covering this matter today. You can ask Mr. Harker if there has been.
Yeah, that's always a problem. He discussed it at some length with Mr. Kuipers, and then somebody else comes in that doesn't have the background. Are you with Velo Law?
That's happens a lot. Like you'll have the leading attorney that come in and make an appearance for the court in the very beginning just to make sure that the matter is cared for, and then they go ahead and they delegate it out to another attorney, and they come and show up for some subsequent hearings. That's not abnormal, but in this case, it does give some kind of rise to issue because Mr. Feynman is unfamiliar with the judge's request.
Office, or you're just covering
No, I'm
that?
not. I was asked to go to this hearing.
Yeah, the rules changed, and people were supposed to provide an appearance for a temporary assignment, but then when COVID hit, it all just fell apart. So I get people to show up. I have no idea where they're from, what your address is, what your phone number is, whether you're with a firm or not, and you don't have any background information. So, Mr. Harker, what's your position?
Well, Your Honor, I'm going to start from the beginning. Hanson sent a salesman to my home.
Well, listen, I don't have time to start at the beginning, at least not right this minute.
So this is a good lesson on how to present your argument. The beginning may be important, but you don't say, I'm going to start from the beginning. You would say, the plaintiff asserts that we have a contract, but Your Honor, is my position that the plaintiff breached the contract. In the beginning, they presented that this would be what they would do. They would insert this particular item, that particular item. And in fact, they did a bait and switch and put something else into the house. They installed a different medium for which does not have the same quality or even better quality. And according to their contract, they proclaimed that they would in fact upgrade to a better quality in the instance of not being able to install what I've requested. However, they did not. They have downgraded it. I have a contractor waiting to testify, or I have a report from a contractor that shows that these two are not one and the same, and in fact, it isn't a downgrade. So since they have breached their contract, Your Honor, I don't believe I owe them anything. That would be a good way to flow how you want to bring in the beginning and really what the court needs to know. But unfortunately, not having an attorney to represent you puts you in a place where all you want to do is tell the whole story. And the court does not have time for the whole story, right? So be mindful. Having professionals do professional things gets you a really long way. It really does, because they have an idea of how to incorporate what you want the judge to know, is that they did a bait and switch, that they came and represented one thing, but yet they performed something different, and it's not in accordance with the contract. You want the judge to know those particular points and base it upon the factual backing of having a third party representative do a report or an affidavit to your claims. But it doesn't work that way today. And this is not advice. Oh, sorry. This is not advice. This is my commentary. This is my opinion. You know, seek out a professional, have them advise you, you know, pay professionals to do professional things. And if you need a referral, I can give you one. Okay.
They filed a motion for summary disposition. Do you know what that is?
No, not totally. I'm not a
No,
lawyer.
that's common. Lay people are very unfamiliar with the concept. They did file a brief and pleadings, and so I'll ask Mr. Flyman to speak to that first. He contends that there are material issue of fact. What's your position with that, Mr. Flyman?
There are no material issues of fact, Your Honor. As you know, this was a contract to install gutters. Defendant's answer, he admits entering into the agreement, but he states that.
So that's the difference between an attorney and a layman person's response. The judge says, one side contends that there's a material issue of fact, and the attorney answers that question off the top, but yet now he's starting to talk about all these other facts, starting to talk about his position, talking about what he wants the judge to know. That's something that Mr. Keith would have benefited from having an attorney when he was asked, because he does have a great set of information that he does lay out, but the way he lays it out does not present well, and he does not show the material issue. He does not point to the factors and have the actual evidence to back it up, like a third party contractor, general contractor, or specialty contractor that can speak to the differences of the gutters, or even the manufacturer contract affidavits. He has nothing, no evidence to speak to his particular position. So his position becomes theory. And as much as the law, you may practice the theory of law, but the reality is the law does not judge theory, it judges facts.
That it was a different gutter grade
Provable.
system that was installed.
I should say, I'm sorry, it judges provable facts. A lot of times people will say, this is what happened, this is what it is. And you can be 1,000% correct, but can you prove that set of facts? And when you cannot prove the set of facts in a non-objective way, then you are going to lose, because the law is looking for the provable facts, not the how would you say it? Like like, oh, it's common sense that this would be the case, or cognitive thinking would surmise that this is the outcome and this is what happened. It has to be provable. You can't just make summations about it.
I think that's what the essence of the issue is. But my understanding is the plaintiff was unable to install the gutter grades requested, so they were substituted for a product of similar quality, and that's per paragraph 1 of the terms and conditions of the agreement, the operative language.
So here's the material fact at issue. Here is the material fact at issue, but yet not having an attorney for Kenneth Harker, it doesn't get out there. Kenneth Harker believes that the contract, whether it does or not have the contract, Kenneth Harker believes that the contract says an upgrade will be made, not similar grade, but upgrade. And Gary Feynman believes that the contract says similar grade. Upgrade and similar are two different wordings, and they mean a million miles away from each other. They don't mean the same thing at all. And so whereas Kenneth, the defendant, feels like he has justification for fighting to pay the full amount of this particular contract, Gary is like, no, because the contract allows for similar, not upgrade.
Which is contractor or its manufacturer may at its sole option upgrade a product to similar or higher quality. And then as you referenced, Your Honor, the plaintiff.
So that's, now I would say the contract is ambiguous. The contracts, according to Gary's read, says upgrade to similar or higher quality. You cannot upgrade to similar quality. You cannot, so you would substitute. That word upgrade shouldn't be there. That is a misrepresentation. It should say substitute to a similar or higher quality, but it says to upgrade to a similar or higher quality. And the word upgrade is what Kenneth is arguing. He's saying that to upgrade to similar is not is a mute subject. To upgrade is only to upgrade. You can only upgrade. If you're going to upgrade something, you can only upgrade it. You can only bring it higher quality. You can't upgrade to the side. You can't upgrade to similar. No, that's a substitution. And so the representation in the wording could be argued very well with a contract lawyer to, you know, argue those particular issues there, but unfortunately, he did not bring his lawyer today.
Did credit the defendant $513 for the substituted product. And also procedurally, defendant listed no firm defenses to their answer. Plaintiff mailed defendant requests for admissions on or about April 18th, 2023. Plaintiff has failed to respond to those. I don't need to cite the case law that says that if you don't answer, they're deemed admitted. So for all those reasons, Your Honor, there's no issue of material fact. Plaintiff is entitled to judgment as a matter of law pursuant to MCR 2.116C9 and 2.116C10.
Okay, so this attorney started off with answering the judge's direct question. Then he laid out some of his points in his motion. Probably, I'm sure his motion delves into these particular points of what the contract says and how there was a substitution made and there was a credit given for that substitution. So he gets his points in and he ends it reaffirming the answer that he gave to the judge for the initial question. So that's the flow of an attorney's response to the judge. Gives a much more poignant understanding, communicates the language that the judge respects, you know, because it's a legalese conversation. He gives some law citations, so that's helpful for the judge to flow with. Just generalized communication that you would have at the dining room table of how your day went and how you woke up this morning with a crick in your neck and all of the details of life is not what presents well in a court, because it sucks up time, and court really just wants concise and pertinent information. So you have to be detailed in a concise way. You have to be poignant and specific in order to, you know, flow with the court well enough to get your points across. But he does say that there's no material facts. I have a disagreement to that. That's just my opinion. I believe there is a material fact of issue, but the problem Mr. Harker has is that he did not answer his discovery. So what Mr. Feynman presents is that they did a request for admissions, which is a part of discovery. And since he did not respond within the 30 days, well, for California, it's 30 days, depends on how you're served, you know, look up your own laws and find out your own days and stuff like that. But you respond in a timely fashion. If you can't, then you get an extension, but you make sure you respond in a timely fashion so that you are answering those particular discovery questions. Do not fail to answer, because here you are in court and all of those admissions are now deemed true. So admissions are written like, admit that you signed this contract, admit that you agreed to all the terms of this contract, admit that you had gutters installed, admit that you owe the plaintiff X amount of dollars, admit that you, and then if you don't answer and say, no, I do not admit, now in court, you've had all of those admissions granted or, you know, deemed as factual. And now they're saying, well, then there's no issue because you've already admitted that you owe this money.
We would request that an order be entered, granted motion.
All right. Now, Mr. Harker, what do you want to tell me?
Okay, the salesman should have known when he came and looked at my place that the gutter drape system couldn't be installed with my steel roof. Never said a word about it. And I was never notified before installation that they were changing from a gutter drape system to a gutter RX system. And the gutter RX system is not an upgrade. The gutter drape system had a 100% clog-free guarantee with it. The gutter RX system had a flat aluminum that sat down inside the gutter.
There's a problem right there. If you're going to counter that the two are not one and the same, then you need to give the facts of the same regard. So he describes sample A as, you know, gutter A as having 100% guarantee non-clog system. And then sample B, he starts talking about a plate 3/4 inch. That's not the same. So you should be responding that sample A has 100% guarantee, sample B does not. Sample A has the ability to not clog at 100%. Sample B can only not clog at 80%. These two are not one and the same. You have to make sure that when you're presenting an evidentiary comparison, that you're doing it in the same measurement. So if you're going to say statistical percentage of success for one, then you need to do a statistical percentage success for the other. He doesn't lay it out that way, so it's kind of like, well, so what? So this one has a 3/4. He does say why he thinks that is a problem, but he doesn't do it in the same evidentiary format. So it becomes kind of like washy.
3/4 of an inch or so. That is not a gutter protection as far as I'm concerned, because all it did is fill up faster. And there's a picture, exhibit 2 in the paperwork that my lawyer sent. And it explains that it's sole option to upgrade. It is not an upgrade in any means. Now, if they had told me they were changing from the gutter grate to the RX system, I would have said, no, I don't want any of your stuff. And I told them to come get it because I didn't want it. And they refused to come get it. So I offered them what I thought was a fair price, because the outfit that put my my gutter protection on, a good gutter protection, they would have installed me gutters for in the neighborhood of $1,200. So I think I'm being way overcharged for their gutters.
Well, that's not a defense. We talked about that last time.
Well,
You signed this contract.
I know
And
that.
so if you go out later and find out you could have found the product cheaper. Now, did Hanson's actually install the gutters?
Yeah, they installed them, but they never told me that they were putting.
All right, so you believe you don't owe them anything? You just get to keep them and they don't pay anything?
No, I offered them what I thought was a fair price for the gutter.
Well, are you an expert in
they
home
can-
construction where you just decide what a fair price for this is?
Well, do they get to just decide what a fair price?
So you don't ask the court questions like this. Judge Middleton, he's so even keel. He's chill. He knows his township. I don't know how well acquainted he is with this particular litigant, but he's very chill. He responds in a way that doesn't off-put a person or put them on guard. But if you were before a different judge, you might get yelled at and your head shoot off asking them questions, because it's not the way court works, right? It's not up to the court to give you advice. It's not up to the court to answer your questions. You are there presenting your case, so the court will ask you questions so that it can understand what you believe to be the position, so that when it rules, it knows that it has found based upon all the facts. So you have to give them the facts, right? So don't get an attitude and start snapping back at the court. But also, this is improper. Like, even if you were a general contractor, I think the court would still require you to have a third party's opinion that has a professional license, not just, oh, well, I could have gotten it from somewhere else cheaper. Okay, buyers beware, that has nothing to do with the fact that you entered into a contract. And you can't go off into, well, it's not worth that amount if you in fact are not a contractor. But even still, because you would have a bias, because you of course would charge yourself less to do a project because it's you, right? Even if you did have workers underneath you. So you want to get a different contractor to come in, give you a professional bid in writing, and let you know what they would do, and get maybe a couple of them so you can show to the court, listen, they are completely overcharging for this subpar material, and this is why it's subpar. It's doesn't have the 100% statistical this, and it doesn't have that. Da, 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 da. You lay those things out, you have a better case performance. This here is more of a buyer beware, seller beware, homeowner beware advertisement versus a good assertion of your particular position in this matter.
Cases they
have a contract that you signed and initialed in about 25 different places. 1-800-Hansons didn't just show up one day and decide to go into this business.
And I also believe that an attorney would say, well, Your Honor, I want to sever this particular paragraph number 1 because the language is ambiguous and counterintuitive. You have the word upgrade to a similar or upgraded version, and you give the layman person or any person, a reader of this contract, confusion as to what you will do in the event you come to a position where you can't install what was purchased. you're going to upgrade it or you're going to substitute it. It doesn't say upgrade and or substitute. It just says upgrade. So a person reading it would want you to upgrade the product, not give a similar product, but to upgrade it. So you have these particular competing words that are improperly put into this paragraph. I would, I would want my attorney to argue to sever that particular paragraph. And then once you sever that paragraph, you can start now arguing more poignantly the fact that they did not install what you purchased. But because he does not have his contract attorney here to argue the contract, he's arguing facts that don't help him because he's really in here for contract law. Contract law meaning you agreed to this. This is what you agreed to. You're not happy with what you agreed to, but this is what you agreed to. So you read your contracts, you send 25 different places. It sounds like maybe a 2-3 page contract. I'm sure they had him initial at each paragraph. So with that being the case, you could easily send that off to your attorney and had them, read it. I had someone call me today and was like, want to sign you up for some kind of forgiveness program and I said, well, I don't know you. You're calling me. I'm not calling you. I don't know that you say who you are. So you need to send me something in writing before we proceed. And I'm waiting for the written communication in the mail. I'm not getting ready to just talk to you and give you all my personal information. I don't know you. So if someone comes to your door and they want to sell you new windows or gutter system, we all need those things for our houses. These are great salespersons. They come around and it's perfect for you to get it. But when you get the contract, say, okay, I'm gonna send this off to my lawyer. I'll call you and let you know when I sign, I'm ready to sign. You don't have to sign on the spot. You do not have to sign on the spot. You have time. You can take your time to read it and you can take your time to send it off to your lawyer and get a response back in a week from your lawyer. Don't be on a rush timeline because somebody else is in a hurry for a commission. That's not how your life works. You are on your timeline. Otherwise, when you sign the contract, you're bound by the contract. Don't ever come to the court saying, well, I didn't read that part. No. You were supposed to.
You got a contract. He also mentioned something that kind of went over your head. They sent you a request for information and you didn't respond to it. When you don't respond to it, everything in there is assumed to be correct as they allege. So they filed a discovery request and you didn't answer it. So the motion for summary disposition is a motion that says the defendant has not stated a defense and there is no material issue of fact. That's what their contentions are. That's 2.116C9 and C10. Mr. Felt helped you file this original answer, but then things have happened since you filed the answer.
And I didn't understand that part of it.
I'm sorry, go ahead.
I say I didn't understand that part of it.
Well, I know you're at a disadvantage. They've got a lawyer and you don't. And there's certain court rules that apply to this and you haven't complied with the court rule. And this motion for summary disposition, I deal with this a lot. Regular people don't understand it. In fact, a lot of lawyers don't understand it. But 2.116C9 and C10 are both very common, the most common reasons people seek to enforce.
And so the judge is being very explanatory, which is great because it helps us. And of course, it helps this litigant and any other litigant in the future to understand. Obviously, you need a lawyer, point blank, period. But what he's also adding to the disposition is understanding the particular citations of law that's being assigned to this motion. And he's stating that it's based off of non-material fact. And the reason why Mr. Feynman asserted that particular information, that the defendant did not have affirmative defenses in their answer, as well as they did not basically deny, because it's a they propounded request for admissions. I'm sorry, which means they requested admissions from the other side. And those particular questions, because they're interrogatory, they're questions, the admissions, they become non-deny. They now are admitted. So these are now facts because you did not deny them. You did not say, no, I don't admit that. No, I don't admit this. And no, this is incorrect. You didn't make an answer to those particular requests for admissions. So they become deemed factual. And so now that they're deemed factual, there is no material fact. So this is where the non-material fact comes into play because of the discovery that wasn't answered. Though in the conversation, like I said, I see some material issue with the contract itself. Some of the language is ambiguous. And then you have, Mr. Harker's concern about subpar quality. But when you go into contract with a salesman or a subcontractor or a general contractor, you put in a pool, you redoing your bathroom, and you sign these contracts. Make sure you know what you're signing. And I'm not understanding why Mr. Harker, who wanted a particular product, when they came to install it, I don't understand why he didn't look at the product first and say, well, what is this? What are you putting up? What is the product you're putting up? I do that. I look at the product. Let me see the granite. Let me see the porcelain. Okay, yeah, that's the one I picked out. You want to make sure that before they even get started, they have the materials that you actually picked out. Now, it could be the installation process is different and he didn't realize that they were a different grate system, even though, because to me they look the same. I'm a woman. It's a long, it goes around the house. It catches the rain, but it sounds like it's the one that has the blockage so that the leaves don't fall in it. That's the one he wanted. But he ended up getting another one, which I would be mad too. Because if I wanted the one that doesn't have any leaves in it, but yet you have a plate that's down further that you get half the leaves, like what's the purpose of they having a crate at all? You might as well have the regular one without the little crate in it because it's catching the leaves all the same versus not letting them into the system. I don't know. That's where I don't know. That's my layman contractor response. I don't know. But as a homeowner, I bet you I would find out if you're getting ready to put that into my house, I'd be looking at your product. I'd be like, open the box, let me see what you got. Okay, what you putting up? Let me see how's it go. Where are you gonna put it? And the contractors hate me because I ask all kinds of questions.
A summary disposition motion.
Okay, can I ask something else here?
Yes.
It states right here in the agreement, it says this agreement cannot be changed by any conversations between owner and contractor. Any changes must be in writing.
What clause are you in?
I'm in the same, it's exhibit 2. It's the same one.
What paragraph?
Paragraph 1.
All right.
And that's where it goes on to say any changes must be in writing and signed by owner and contractor. Contractor or its manufacturer may add its sole option upgrade to a product, which that was not an upgrade. Similar higher quality.
Yeah, the problem is this is cut off. So the copy that I have, it starts on page 1, it goes to page 2, and some of the important language is missing.
See, that's my whole point with this whole thing here is they never let me know they were changing anything. They just came and did it, threw it up, and then said, and then they never told me even after they installed it. I had to get up there with a ladder and find out that they had changed it. Otherwise, they would have charged me the full price.
Well, they gave you a credit, but it says unused materials. So I'm not sure what that is.
Well, they claimed that was a difference in cost between the two. So if it.
Okay, so see, you were winning on that subject. You should have kept your mouth shut. It's up to Mr. Feynman to prove that the credit was for the difference in the upgrade of cost, meaning that the way he's saying is he got downgraded. So they're telling him it's a $500 difference between what you would have got versus what you did get. And he's going off and telling, oh, well, they said that was because of the difference between the two products. But the written contract says it was a credit for non-used materials. So let the word speak for itself. Don't overtalk the contract. You could have won on it. You could have got points on that, but you didn't. You took it off because you talked and you cleared up the record for something that had nothing to do with you. That was supposed to be Gary's job, and he don't know, and he didn't open his mouth.
If it's an upgrade, then why does it cost less than the better one? It's all, there's no upgrade.
And he keeps fighting on this contractual issue for this clause, but he did not get an attorney to get that clause severed from the contract. So it's still enforced. It's an enforced clause. Now it's a matter of interpretation, and the court's going to interpret the fact that the job was done. You got a job done. Now you got to pay for the job.
whatsoever to it. And if they had let me know before they installed they were changing it, I would have said, no, I don't want any of it.
Talking,
They never gave me the choice to back out on it. They just went ahead and put up what they wanted to put up. And it's that I got a picture in exhibits here too that shows it was less than a month and it was completely clogged full of junk. That is not 100%. It's exhibit 6. You can see how well it works. I might as well not had anything in the gutter. It might as well just been open. And that's not what I wanted.
That's what I said. Oh, I'm so sorry. I'm not laughing at him. I'm laughing at me because I'm guessing as to what this is. I'm guessing to which gutter it is versus another gutter, just because of the commercials I've seen. I'm in real estate, but I'm not I don't go on the rooftop. You know what I mean? So I'm not really looking. So I'm really guessing, and that's what I'm saying. Like, who wants to have, like, just take the crate out? That's a waste of material, because if you're going to collect any leaf at all, whether you collect the full amount of leaf or a little bit of leaf, it doesn't make a sense to me to have the crate in at all. Because now you still have the cloggage of the leaves. You got to rake them out. That's the way I see it.
The whole reason that I ordered the thing from them is because they had the 100% clog-free guarantee. That's the kind of stuff that I wanted. Now they're forcing me to pay their outlandish price on just gutters, and I don't want just gutters.
Your Honor, as you mentioned, improper defendants are subject to the same core rules as everybody else. There was no response to this motion, no response to the request for admissions.
You gotta love Gary. Gary cannot fight the fact that the contract has ambiguous language, so he's going to ignore it because it's really not an issue that has been brought up. It's being said right now at court, but there was no affirmative defense. There was no answer to discovery, so they're not on notice of it. So when you come to court, both sides should already know what they're arguing against. They should know your position already. So what Gary is saying, we don't know his position. So all of these assertions he's making now in court have never been told to us. In fact, he admitted all of our facts. So the stuff that he's asserting now is mute. That has no bearing, because this particular case has not, this particular defendant has not asserted any defenses or any facts prior to right now. So Gary's just bringing it straight back to the law. The litigant, the defendant, of course, is hot to trot about it because he didn't get what he wanted. And he would have been happy to pay for what he wanted if that's what you put in, but you changed it. And he feels like he's been hoodwinked. He didn't know you were getting ready to change it, and it's not something he wanted. So he's very animated. He's telling it all. And Gary's like, look, none of this is in here, so it's hot air for now. We want to keep it with the law.
He can't just keep this for free. He got the gutters. He signed an agreement. There is a clause that says they can provide a product of similar or higher quality, and he got a $513 credit for that. And there's really no.
Gosh, if he had an attorney, I would say no. I got a $513 credit for what it says, Your Honor, which is lack of use of materials. That's it. They didn't use all the materials, so they took that back and they credited me for the materials that they didn't use. But they put in materials that I didn't want.
No issue here, Your Honor. This motion ought to be granted for all the reasons you stated and for the reasons I stated.
Well, it sounds like he did not get what he wanted, but you're right. We're not in small claims court, Mr. Harker. We're in general civil court, and the rules of procedure and evidence apply. And you didn't comply with either of those. They filed this motion. You didn't make any response. They requested a production of documents or information for admissions, and you didn't respond to that.
So you hear what judge is saying? Small claims court. If you were in small claims court, which has to have a $25,000 amount or lesser, I think it's just up to $25,000, right? So a little less than that. In valuation, you would have the benefit of, okay, I'm in pro per. We don't necessarily have to follow rules of procedure in the same format, but you're in general civil litigation, which means you do have to follow the rules of procedure, whether you're in pro per or not. And so that's what Mr. Feynman alerted to the judge, I want to assert this judge that we are in fact bound by civil rules of procedure, regardless if improper or not. Judge, of course, affirms the same, and that's the information that he's giving to him now. Now, be mindful that Mr. Harker is not the one who filed the complaint, right? So he didn't say he wanted to be in small claims court. He just got the notice that they're taking him to court. So it was not necessarily Mr. Feynman himself, but the plaintiff is the one who filed the complaint, and they just selected what court they were going to go to, whether general civil court or small claims court. But obviously, it has to do with the amount, and I assume the amount is less than $25,000, but for whatever reason, they chose to do general.
So those admissions are accepted as true. So I don't have to like this. I don't think you got what you contracted for. I think you paid a very high price for it. I don't think it works. And you can certainly appeal this, but the same rules apply.
You see that? So you see where you could have won? Contract. You did not get what you contracted for. Don't think it works. Yes, you paid a high price for it, but you signed up for the contract. And the problem with it is you didn't get someone to argue that paragraph 1, that clause 1, to get that severed, so it becomes enforceable. So they're allowed to upgrade you to similar, even though to me that is contrary. It's an oxymoron of statements. It's quite contrary in its understanding, but nonetheless, they did put a product in, and you accepted the product because you let them put it in, and you owe them the rest of the money for it.
As if you had an attorney. And because of the fail to answer the request for admissions, there is no material issue of fact, and you failed to state a defense. You can review this with Mr. Felt, but I don't have to like this. In fact, I don't like it, but I have to follow the law. I find summary disposition for the plaintiff. The defendants that are unrepresented in general civil cases of big corporations often end up on the short end of the stick. There was settlement discussion that went nowhere. You decided to pay them what you thought was fair. I don't know how that was determined. I don't know. They did have lengthy discussion to settle it, which failed. Now I heard this motion. You owe them $4,655, $154.41 in costs, and a $75 statutory attorney fee, for a total of $4,484.41.
No, it's $4,884.
$4,884. I couldn't see it. The print's so small. 4,884.41.
Your Honor, will you be preparing that order, or would you like?
There is an order here, and I'm signing it.
Okay.
This is not a rousing advertisement for 1-800-Hanson's.
No worries. We're not calling them, Your Honor. We're not.
Out to the parties, Your Honor.
Yes. Mr. Harker, I suggest you might want to share that with Mr. Felt. He can watch this proceeding on YouTube if he wishes to, but I find on their behalf.
Now remember, Mr. Felt is Mr. Harker's attorney, but not of record, right? For whatever reason, because he's not here for the hearing. So he's saying you might want to appeal this. If you do, make sure Mr. Felt sees this so he can go about it in appeal. Basically, he's saying use your attorney.
I don't have to like it.
They're done.
All right, that completes this matter.
Attorney.
Thank you, Your Honor.
Right. So that's the conclusion of this matter. So we've learned a great deal because it was a civil matter. It was a contract matter. It just involved a lot of the things that us homeowners go through. We want the solar system because we're sick of paying, the high pricing on electricity. We need the solar system because we're getting the electric car, right? Or we need the gutter system because, the trees, we don't want to cut them down, but the leaves are getting all into, and the little beads are getting all into our gutters, and we want the new system, right? We love the video. We love the commercial, right? We want it. Okay, well, that's great. As the homeowner, or any person, when you're getting into a contract, you're bound by the clauses, and the clauses are the paragraphs. You're bound by the paragraphs that are in the contract, and whoever wrote the contract is going to make the contract most favorable to their position, right? So um, they might be willing to negotiate and they may not be willing to negotiate. So you find someone else who's willing to do what you want. What you can do is just buy the material and hire a handyman to put the gutters up, right? Because now you're not bound by a company's contract, right? Sounds like it was somewhere $4,000 for these gutters, and he thinks he can get the same gutters for 1,200. That's a major difference in price, major difference. So we've learned how we can operate as homeowners so that we don't get a lien put against the house. Because what happens now, they have a judgment. They have a court judgment, and that means you have to pay it. You don't pay it within a timely fashion, it becomes a lien against your house. It gets recorded against your house, so that when in the event that you want to sell your house, or you want to refinance your house, or you want to do anything financially in concern of your house, you are unable to because you have a lien on it. You have to first satisfy the lien. The bank will make you pay the lien off before they'll refinance you. And then when you sell the house, you got to clear up titles. So you got to, deal with those elements. So you don't want to have a lien on your house. Okay. And you want to keep the title clean as possible. This is one of the ways you get a lien on your house, because you buy something you don't necessarily want because you don't get the product that you want. And now you want to fight it in court and you lose anyway because you didn't have your attorney come and argue the contract. So let professionals do professional things. Sometimes that cost is important to pay out, because you may have found yourself in a more favorable position arguing the fact that the contract is ambiguous, and that and if they have the severability clause in there, because if they don't have the severability clause, then you can argue to throw out the whole contract versus just severing that one particular paragraph. But anyway, if you get a contract, before you sign it, send it to someone who can read it and explain it. Understand what you're signing. Read it for yourself. Read it a couple times. It's okay. You don't have to be the speed reader of the day. Read it a couple times. Understand what you're signing up for. And the other thing we've learned is that judges a lot of times will find themselves in positions that they have to rule based upon the law, even though they're not in agreement with the outcome. Judge Middleton is not necessarily in agreement with certain aspects of this outcome. However, the law is the law, and we all abide by the law so that we have a system of fairness and we know what is expected of us, right? I have people who are like, Cleric, you're so, they'll say, I'm very matter of fact, right? It's yes is yes, no is no, no flurry expression, no no colorful language. It's just yes or no. I'm very straightforward. And I'm like, yeah, I like that because it's a very consistent way of communicating. Because when you are very fluffy and colorful, you give confusion to what you mean. And so I want you to understand what I mean and where I'm coming from. So if you're ever in the position again, you know where I stand on the issue, and you don't have to guess. And that's the way the law is. It's straightforward. It's meant so that you can follow it and everyone can abide by it without issue. So it can be harsh. It can be something we don't necessarily agree with all the time. However, until we pass new laws and new legislation, that's the law we have to abide by. So the judge has to enforce what's there. And we have to know our rights and our responsibilities. So we've learned a little bit relative to being a homeowner and how we can avoid finding ourselves getting a judgment and getting it put on a lien on our house. So hopefully you learned, and you can like, share, and subscribe. Make sure you share this out so that others can learn too. And we can keep doing what we do here. Thank you, Judge Middleton, for coming back. Court is in session and we're happy. All right, Lyric Armstrong, your real estate agent and advocate.